King Cohenor Plaintiff, Pro Seor 1035 Olive Ave, Ramona CA, 92,065 or 6195-99411, 6 or 67, kingdavid.cohen@gmail.comer. The United States District Court, Southern District of California Jurisdiction. King Cohen Plaintiff versus AKA San Diego State University, Case No, to be assigned. Complaint hearing date, time, courtroom, AKA CZ. Defendants. Amended complaint for injunctive relief, declaratory relief, and damages. I question. The wall between church and state is not just a line, it's a sacred boundary by constitutional design. Must be kept high and impregnable. Justice Black gave the call. Did SDSU answer, or did SDSU bulldoze it all? Second introduction. This case is not about academic policy. It is about constitutional principle. It is not merely whether San Diego State University could reopen a resolved matter, but whether it did so in retaliation for a federal civil rights complaint, and whether such a reprisal can stand in a republic governed by law. The facts are not in dispute. A student in good standing, nearing graduation, submitted a work of conscience, an assignment forged not for provocation, but from intellectual integrity and spiritual conviction. The professor raised a concern, reviewed the work, and ultimately found no misconduct. The matter was closed, the gavel fell. But what followed was not discipline, it was retaliation. Exactly 1 year after the plaintiff filed a federal complaint with the U.S. Department of Education's Office for Civil Rights, SDSU exhumed a sealed file. No new evidence was presented, no procedural authority was cited, no student or faculty witness emerged. The university acted not with lawful purpose, but with vengeful timing. This was not a good faith reappraisal. It was reprisal in ceremonial dress. Retaliation with a calendar in one hand and a sanction in the other. Bottom line, SDSU violated the 40 working day deadline set by Executive Order 1098, trampling its own guardrails in its haste to punish. Due process was discarded, accommodations were ignored, warnings were never sent, rights were not suspended, they were abolished. The plaintiff was not afforded notice, evidence, or meaningful opportunity to be heard. Instead, he was summoned without warning, silenced without evidence, and burdened without guilt. All this, not for academic dishonesty, but for daring to seek federal protection under civil rights law. In this, SDSU did not merely act unjustly, it acted unconstitutionally. The First Amendment forbids retaliation against protected speech. The 14th demands due process and equal protection. SDSU honored neither. It wielded silence as strategy, delay as weapon, and policy as pretext. This court is not being asked to referee a student dispute. It is being asked to confront the quiet, bureaucratic cruelty of a public institution retaliating against one of its own for seeking the protection of federal law. And if this act is permitted to stand, if process can be hollowed, timing weaponized, and conscience punished, then the Constitution is not merely bent. It is broken. Let it be said with clarity and force, SDSU's conduct was not a misunderstanding. It was a flagrant message. And if the federal courts do not answer it, then every student who writes boldly, speaks freely, or files lawfully may soon find their rights replaced by retaliation. Third parties. A. Plaintiff is married and caretakers to 8 children. Plaintiff King Cohen is a student formerly in good standing at San Diego State University, SDSU, and a resident of California. B. Defendant S. San Diego State University, also known as the Board of Trustees of California State University, is a public institution of higher education and a state actor under color of law. San Diego State University, also known as the Board of Trustees of California State University. A ponderous phrase, to be sure, and one whose length may weigh heavy upon the parchment of these proceedings. But to ease the burden of repetition, and to preserve this court's valuable time, plaintiff shall henceforth employ the abbreviation SDSU, which shall be understood by all parties and by this honorable court to signify the full legal name, the Board of Trustees of the California State University, acting through San Diego State University. C. Defendant T. Dr. Lee Mintz is the director of the Center for Student Rights and Responsibilities and is sued in her official capacity. D. Defendant U. Ms. Brianna Brussel is a student conduct administrator and coordinator at the Center for Student Rights and Responsibilities and is sued in her official capacity. E. Defendant V. Full name unknown is a president of student affairs and is sued in her official capacity. F. Defendant W. Full name unknown is a vice president of student affairs and is sued in her official capacity. G. Defendant X. Full name unknown is an associate director at CSRR and is sued in her official capacity. H. Defendant Y. Full name unknown is in campus president at San Diego State and is sued in her official capacity. I does 1 to 10Z are individuals whose identities are presently unknown who participated in or ratified the conduct described herein. Fourth, table of contents. A question, introduction. 1B in introduction. Table and C party. Table manner. The table of contents. The table of content. Authorities. Authority. If jurisdiction and venue. Add. Claim. F. H. Factual allegations. I summary of argument. J. Argument. J. Counter argument. 17. K. Counter arguments. 47. La prayer. An enjoyable manner. Demand for jury trial. United States. And conclusion. Fifth authorities. 55. Fifth authorities. Freedom of speech, religion, assembly, and petition, invoked as the sacred shield against institutional retaliation for protected expression. N.U.S. Const. 14. SS1 due process and equal protection clauses, invoked as the twin sentinels of fairness and equality, guarding liberty from arbitrary state power. B. Federal statutes. N29 USC SS 794, Section 504 bars any program or activity receiving federal financial assistance from excluding or discriminating against individuals with disabilities. C8 CFR SS 35.130. This regulation outlines that a public entity may not, directly or through contractual arrangements, deny individuals with disabilities the opportunity to participate in or benefit from its services, programs, or activities. 2008 CFR SS 35.160-10. This regulation requires public entities to ensure effective communication with individuals with disabilities, including the provision of appropriate auxiliary aids and services. And 28 CFR SS 35.134. This provision prohibits retaliation, coercion, or threats against individuals who exercise their rights under the ADA. 2008 USCSS 1331. Federal question jurisdiction, ensuring the federal judiciary stands ready to hear cases where constitutional law has been defied. And 28 USCSS 1343. Jurisdiction over civil rights violations, providing the gateway for suits against governmental abuse of power. 2008 USC SS 1367 and in supplemental jurisdiction, extending judicial authority to state law claims bound to the same factual heart as federal violations. And 29 USC SS 794. Section 504 mandates that entities receiving federal funding cannot discriminate against individuals solely based on disability. 142 USC SS 2 101. The ADA ensures equal opportunity and non-discrimination for individuals with disabilities in public and private services, including education and government services. 42 USC SS 12132. Title II prohibits public entities, including schools and universities, from discriminating against qualified individuals with disabilities in the provision of services, programs, or activities. 142 USC SS 1983. The Civil Rights Act, enshrining the principle that no person shall suffer deprivation of constitutional rights by state actors without recourse. 142 USC SS 1988. This statute permits prevailing parties in civil rights lawsuits, including ADA SS 1983 and Title VI actions, to recover reasonable attorney's fees. 42 USC SS 2000D and Title VI prohibits discrimination on the basis of race, color, or national origin in any program or activity receiving federal financial assistance. 145 CFR SS 80.3. This regulation enforces Title VI by barring exclusion or denial of benefits based on race, color, or national origin in federally assisted programs. 145 CFR SS 80.8. This section outlines the procedures for investigating Title VI violations and imposing sanctions, including possible termination of federal funds. Sees United States Supreme Court decisions. Everson v. Board of Education of the Township of Ewing, 330 U.S. 1947, incorporated the Establishment Clause against the states, erecting a high and impregnable wall between church and state, and warning that public power must never endorse or suppress religion. Semblish v. Lopez, 419, U.S. 565, 1975, established that public school students possess constitutionally protected property and liberty interests in education. Matthews v. Eldridge, 424. U.S. 3 due process articulated the balancing test for due process, affirming that even threatened interests demand procedural protection. Tinker v. Des Moines and Depp. CMTI, Dist. 393 U.S. 503, 1969, held that students do not shed their constitutional rights at the schoolhouse gate, an anthem for academic freedom. County of Sacramento v. Lewis, 523 U.S. 833, 1998, defined conscience-shocking conduct as a violation of substantive due process, condemning arbitrary state action. Sierra Healthy City, Dist. B.D. of Ejuk, v. Doyle, 429, U.S. 274, 1977, established the burden-shifting framework for First Amendment retaliation claims. And Nevis v. Bartlett, 587, U.S. 2019, confirmed that temporal proximity and absence of legitimate justification can prove retaliatory intent. In Village of Willowbrook v. Olek, 528 U.S. 562, 2000, authorized class of 1 equal protection claims, where injustice does not depend on numbers, but on the betrayal of fairness. Hope v. Pelzer, 536 U.S. 730, 2002, stripped qualified immunity from officials whose cruelty was obvious, proving that constitutional violation needs no twin precedent when the abuse is plain to the eye and conscience. D. California State Law and Cases. In Cal. Civ. Code SS 52.1. The Bain Act protects individuals in California from interference, threats, or intimidation in the exercise of their constitutional or statutory rights, including via excessive force or retaliation. KJV Jackson, 127, 4th, 1239. February 11th, 2025, affirming that students facing new disciplinary charges must receive notice, the evidence against them, and an opportunity to respond in line with Goss v. Lopez. Zumbrun v. University of Southern California, 25 Cal, App 3D1, 1972, held that published university policies may create enforceable implied contracts when students reasonably rely on them. And California Education Code SS 76224A affirms finality of faculty-assigned grades and academic discretion, absent fraud, mistake, or arbitrary conduct. University Policy and Authority, California State University Executive Order 1098, the procedural scripture governing student discipline in the CSU system, mandating timely resolution, due process, and administrative integrity. Constantine v. George Mason Univa, 411, F3D, 474, 4th Sierra, 2005. The Fourth Circuit held that a student's exclusion from education services due to discriminatory retaliation for asserting ADA 500, and for rights stated a valid claim, affirming that public universities may be liable under Title II and Section 504 for such violations. Sixth, jurisdiction and venue. This court has subject matter jurisdiction under 28 U.S.C. SS 1331 and 28 U.S.C. SS 1343 because plaintiff alleges violations of federal constitutional rights under 42 U.S.C. SS 1983. A. This court has supplemental jurisdiction over plaintiff's state law claim pursuant to 28 U.S.C. SS 1367. B. Venue is proper under 28 U.S.C. SS 1391b because the events giving rise to the claims occurred within this district. Seventh Statement of Claim. A. Plaintiff King Cohen and proceeding pro se alleges the following against defendants. Eighth, factual allegations. A. The journey begins with academic integrity and honest faith. In the twilight of his academic pilgrimage, the plaintiff, a devoted student at San Diego State University, SDSU, approached the gate not with cynicism or calculation, but with conscience. His final paper, No Idle Scribble for Grade-Chasing Glory, was crafted as an offering of truth, forged in the crucible of religious conviction and scholarly rigor. The theme, religious identity. Dr. Thomas's, the professor assigned to evaluate this work, suggested he noticed AI usage. Thus, Dr. Thomas's, without considering if plaintiffs had right to use AI, alleged misconduct occurred. But later, after Dr. Thomas's examined the matter in its totality, Dr. Thomas's rendered judgment. No misconduct occurred, and with deliberate hand. He reached out to the Center for Student Rights and Responsibilities, CSRR, requesting the matter be quashed, closed, and buried. The sword of suspicion was sheathed. The case, sealed in administrative tomb, was to be no more. And on May 16, 2024, the plaintiff graduated. His conscience was clear, his record unblemished, his journey complete, or so it seemed. But justice at SDSU is not a fortress of stone. It is a thin tissue of charm and paper, easily lit, easily burned. The university violates its own closure. Resurrection without cause. What had been buried was not allowed to rest. The corpse of the case, cold, judged, and lawfully entombed, was exhumed by evil administrative necromancy. SDSU, untethered from evidence, from policy, from time itself, dared to make the dead walk again. No new witness cried out. No new document emerged from the shadows. No cause, no complaint, no lawful justification of the unreasonable time accompanied this esoteric resurrection. Only a ritual of silence. And then, like a venomous cobra, SDSU struck at plaintiff with wild and reckless accusations. Indeed, even when plaintiff articulated on multiple occasions the antidote, the accusations made by SDSU have no standing. SDSU, without fear of reproach, kept going, sustaining their attack against plaintiff with wild and reckless accusations. And as if using a forked tongue, whispered sweet nothings of sanctions to plaintiff. Executive Order 1098 stands as a bulwark against precisely this kind of bureaucratic rot. 40 working days. That is the law, not as a suggestion, but as a command. The gears of justice may grind slowly, but they must grind with lawful rhythm. Yet SDSU allowed the clock to die. Then, without ritual, without cause, it pretended the clock had never ticked. Let justice be done, though the heavens fall, says the law. But at SDSU, justice was undone in silence, and the heavens did not fall. They turned their face. The timeline is thus. 1 May 19, 2023. Plaintiff is granted permanent accommodations, including assistive technologies, AI, by SDSU's own Disability Services Division. April 2, 2024. Plaintiff lodges a federal civil rights complaint with the U.S. Department of Education, Office for Civil Rights, OCR case number 0924-2326. 3. August 8, 2024. In the wake of the OCR filing, Professor Thomas's alleging misconduct based on AI use, stating, "It's hard to pin down, but I've read thousands of papers." 4. Plaintiff offers resolution, rewrite, redo, or take a 0. No response. 5. From September 1st, 2024 through April 1st, 2025, the university sends no meaningful communication about whether the case will be accepted for investigation. 40 working days expired October 4th, 2024. A deadline ignored. 6. April 23rd, 2025. Precisely 1 year after the OCR complaint was acknowledged in writing, SDSU sends a written demand letter to the plaintiff. Neves v. Bartlett 587, 2019 has confirmed that temporal proximity and absence of legitimate justification can prove retaliatory intent. The temporal proximity precisely 1 year after the OCR complaint was acknowledged in writing is no coincidence. This is not bureaucracy. This is retaliation in a Day of Dead ceremonial headdress. 28 CFR SS 35.134 prohibits SDSU from retaliation, coercion, or threats against plaintiff who exercised his rights under the ADA. Like a hand to the glove of the 28 CFR SS 35.134, the OCR enforces federal civil rights laws that prohibit discrimination in programs or activities that receive federal financial assistance, such as Title VI of the Civil Rights Act of 1009, Race, Color, National Origin. Section 504 of the Rehabilitation Act of 1973, Disability 2. Title II of the Americans with Disabilities Act, ADA. Still, the irony is no less tragic. Paradoxically, the very institution that currently sells AI subscriptions to all students now unceremoniously prohibits to only one plaintiff. What's worse, SDSU accuses plaintiff, a disabled student, of academic misconduct for allegedly using what is provided and permitted. Zumbrun versus University of Southern California, 25 Cal. At Published University 2, held that published university policies may create enforceable implied contracts when students reasonably rely on them. Moreover, the Fourth Circuit held that a student's exclusion from education services due to discriminatory retaliation for asserting ADA 504 rights stated a valid claim affirming that public universities may be liable under Title II and Section 504. For such violations, Constantine v. George Mason Univiv, 411, 474 4th CR, 2005. 7. Even though the director of the Center for Student Rights and Responsibilities, Dr. Lee Mintz, was personally made aware of the unlawful prosecution on March 20th, 2025, by the Student Conduct Administrator of the Center for Student Rights and Responsibilities. Still, Dr. Lee Mintz did nothing, leaving plaintiff in the rain cold and without a coat. SDSU never paused to consider if the aggression it was wielding was even lawful. Indeed, even when repeatedly informed multiple times by plaintiff of the illegality of this witch hunt, no one cared. Even worse, the director, the administrator, and SDSU victimized plaintiff with legal chicanery. California State University Executive Order 1098, Article 4, F2F orders SDSU to explicitly provide a copy of Executive Order 1098, or notice of where the plaintiff may obtain a copy, must be included with the notice of conference. SDSU never explicitly provided notice of where the plaintiff may obtain a copy of Executive Order 1098. This procedural error is in direct violation of U.S. Const. Amend. XIV SS1. SDSU disregarded the plaintiff's rights to due process and equal protection under the law. If the university is willing to treat an older, disabled student in this manner, one who acted in good faith, complied with all requirements, and one, we offer the resources and training necessary for students, faculty, and staff to utilize AI in their academic, research, and daily endeavors, both creatively and ethically. These AI tools and services are included as part of SDSU's existing license agreements or provided by funding from the CSU Chancellor's Office. Complaint hearing date, time, courtroom, -10. Held a formal accommodation authorizing assistive technologies, AI. What protection remains for a younger, less empowered student? Still, despite his lawful accommodations, despite the absence of misconduct, and despite the completion of all academic obligations, plaintiff was still dragged back into the fire, not by justice, but by institutional willfulness masquerading as procedure. C. Blindsided before the blessing, SDSU breaks trust. The tactics of tyrants are not always loud. Sometimes they are quiet, sent by email. The plaintiff's inbox, like a storm of paper in a bureaucrat's wastebasket, was flooded with trivialities: backstage pass, SDSU commencement, action needed from career services. Hidden among them, like a scorpion in a bouquet, was the sting of accusation. He did not see it, not because he ignored it, but because it was obscured. Nevertheless, SDSU declared, appear May 1st, 2025 at 11 a.m., or be judged without trial. Who can prepare for an unjust trial days before commencement, while at the same time still preparing to welcome family to come see plaintiff graduate? SDSU's conduct was not merely improper, it was treacherously shocking. No hearing preceded it, no facts were presented, no legal notice was granted. It was a judgment masquerading as procedure, a trial without a voice, a dagger behind the diploma. SDSU acted not with the measured hand of justice, but with the cruel efficiency of betrayal. It took a graduating senior, silenced his rights, and threatened his future. On May 12, 2025, Professor Thomas's formally confirmed to both the plaintiff and the Center for Student Rights and Responsibilities, CSRR, that the matter had been quashed. Yet SDSU, unmoved by truth and undeterred by policy, pressed forward. It scheduled a second meeting in direct violation of California State University Executive Order 1098, Article 3, Section B6, which plainly requires that no resolution be imposed without first granting the student a fair opportunity to review it with an advisor of their choice. No such opportunity was afforded, no fairness extended. Then, on May 19, 2025, Administrator Brianna Brazel delivered a demand letter, an ultimatum masquerading as process. The plaintiff was instructed to accept SDSU's predetermined sanctions or face a formal disciplinary hearing set for March 26, 2026, with a registration hold hanging overhead. The sanctions were not rehabilitative but retaliatory, a forced confession of guilt, the submission of a written essay to Brazel, and, most egregiously, the prohibition of all previously granted reasonable accommodations, including those approved through formal disability services and still available to all other students. This was not discipline, it was punishment by policy. That same day, May 19, 2025, Plaintiff King Cohen responded with clarity and composure. He emailed Brianna Brazel, formally requesting a resolution review conference and asserting his unwavering position. He had done nothing wrong. His reasoning was not evasive, but grounded in logic, law, and documented fact. He explained that his absence from the two previously cited meetings, May 1 and May 19, was not willful defiance, but a good faith misunderstanding arising from SDSU's own procedural irregularities and the university's failure to give proper notice. He emphasized that the matter had been declared quashed 3 separate times, including directly by the course professor. In short, he extended his hand. SDSU clenched its fist. On May 20th, 2025, SDSU doubled down. A letter was sent to Professor Thomas's refusing to acknowledge the quash. A separate letter was sent to plaintiff, thinly veiled in contempt for self-defense, claiming that the decision was reached with the evidence submitted by the professor and additional research. Yet no new evidence existed, and the professor himself had already declared the matter resolved. The contradiction was glaring, the process a charade. SDSU claimed to seek understanding. It offered a resolution review to learn more, but there was nothing left to learn. The facts had been made plain, the record was clear. The plaintiff had been exonerated, not once, but thrice. What remained was not truth-seeking, it was face-saving. Despite requesting any day excluding Thursdays, due to plaintiff's role as the primary caregiver to a severely disabled child whose therapy schedule made Thursdays, SDSU set the new hearing date unilaterally for June 5, 2025, a Thursday. The plaintiff, again acting in good faith, requested a modest and reasonable accommodation, Friday, June 13th. He was met not with cooperation, but with silence. No confirmation, no reply, no response. This was not an error, it was a strategy, a deliberate refusal to accommodate, a calculated denial of communication, and a willful attempt to grind the plaintiff into administrative surrender. Public institutions are not permitted to ignore federal law. Yet SDSU did so with impunity, violating both 28 CFR SS 35.160 and SS 35.130, which guarantee effective communication and reasonable modification for individuals with disabilities. And under Executive Order 1098, Article 5, Section D, the university may impose a hold or withhold a degree only until the process is complete. But here, SDSU severed communication, leaving plaintiff in purgatory unable to determine whether the matter had concluded or whether yet another shadow proceeding awaited. Thus, SDSU acted not as an educational institution, but as a vindictive apparatus of unchecked authority. What it sought was not resolution, but submission, and what it delivered was not process, but persecution. D. The veil is torn. The real reason for retaliation emerges. Let the veil be lifted and truth be seen. The paper SDSU now wields as weapon was not the paper that provoked their wrath. In spring 2024, plaintiff given full discretion to choose any topic uncovered a religious cult whose language and ethos, disturbingly, echoed SDSU's own promotional slogans. The essay was over 150 pages, brimming with academic rigor, fortified with primary sources from Harvard and Yale, and footnoted with surgical precision too. For this he was not commended but condemned. He was branded a conspiracist. His grade lowered, his character sullied. He approached CSRR, no help, no investigation, no defense. And then, his disabled child's feeding tube became dislodged. The plaintiff requested grace from another professor. None was granted. And again, the Office of Rights and Responsibilities did nothing. Then the plaintiff filed a complaint with the U.S. Department of Education. And a year later, the hammer came down. But let it be known, it was not Al they feared. It was truth. The tribunal's aim was never to punish dishonesty. It was to punish dissent. The scales are tipped, the equal protection violation. Where others were warned, plaintiff was blindsided. Where others were advised, plaintiff was ambushed. Where others were given opportunity, plaintiff was given silence. The disabled student who followed the law was treated as the outlaw. This is not equality. It is apartheid in policy. Village of Willowbrook v. Olek, 528 U.S. 562, 2000, stands as a pillar of justice. Even a class of one is protected against arbitrary abuse. But SDSU did not apply law with even hand. It wielded it like a cudgel, aiming its punishment not at misconduct, but at resistance. 2 case against Satan. In Satan we trust paper. KDQ WVKOF the AHW C NBKE. Edit. USP equal to drives DK complaint hearing date, time, courtroom, F the cost. A student stripped of rights, dignity, and due process. Plaintiff, a father, scholar, and near graduate, stood on the threshold of commencement. SDSU, a public institution receiving federal funds and bound by the 14th Amendment, thrust him instead into an abyss of secret adjudication. University officials violated their own published policies and the guarantees of due process by summoning plaintiff to a meeting where he was forbidden legal counsel, even as the convening administrator may herself enjoy the full advantage of her bar licensure. See Goss v. Lopez, 419, U.S. 565. Minimal due process protections apply to students facing significant disciplinary action. Plaintiff was not judged by evidence. He was sentenced by procedural void. Notice was perfunctory, opportunity to respond illusory, the outcome predetermined, an archetypal kangaroo court, actionable under 42 U.S.C. SS 1983 for deprivation of liberty and property interests in education and reputation. The California Lieutenant Governor, a constitutionally mandated voting member of both the CSU Board of Trustees and the UC Board of Regents, Cal Const Art IX SS 9, bears non-delegable responsibility for ensuring that system-wide policies comport with the Constitution. That office's inaction in the face of SDSU's abuses constitutes deliberate indifference amounting to state endorsement of unconstitutional practice. C. Monel v. Deputa Sosa. Serves. 436 U.S. 658, 1978. On May 16, 2025, the very day plaintiff should have celebrated academic triumph, SDSU officially sanctioned a commencement address that first cast Israel-America's treaty ally as a genocidal aggressor while omitting the October 7 terror attacks, the 1,200 Israeli deaths, and the ongoing captivity of at least 56 hostages. Secondly, ignored public evidence of humanitarian funds funneled through Qatar to Hamas for military ends 3. Thirdly, offered no candle, literal or rhetorical, for either Israeli or Palestinian civilian dead. By endorsing one-sided political propaganda at a SDSU officially sanctioned commencement function, SDSU engaged in viewpoint discrimination forbidden by the First Amendment, and for Jewish students, created an objectively hostile environment actionable under Title VI of the Civil Rights Act, 42 U.S.C. SS 2000D, and Title IV, 20 U.S.C. SS 1684. Plaintiff and fellow Jewish graduate Liz reasonably feared verbal or physical reprisal and withdrew from the ceremony. Classic chilling effect evidence. Plaintiff is a qualified individual with a disability. Reopening a closed matter and denying him the accommodation of counsel after he engaged in protected speech, raising concerns over anti-Semitism, constitutes retaliation in violation of Title II of the ADA 42 U.S.C. SS 12132 and SS 504 of the Rehabilitation Act, 29 U.S.C. SS 794. Let the record reflect the reality, not the illusion. The plaintiff was not afforded due process. He was denied it in disguise. He was not investigated in accordance with law. He was ambushed under pretense. He was not judged by fact. He was sentenced by silence. The very procedures designed to ensure fairness were wielded as weapons of bureaucratic convenience, cloaked in the robe of neutrality, but soaked in institutional bias. This is not a campus grievance. It is a constitutional rupture orchestrated at the highest levels of California's educational governance. The Lieutenant Governor of California, far from a distant observer, is vested, by Article 9, Section 9 of the California Constitution, with a comprehensive policymaking role over higher education. As a full voting member of both the University of California Board of Regents and the California State University Board of Trustees, the Lieutenant Governor is not a passive figurehead, but an active architect of policy and protector of institutional conduct. And herein lies the rot. Through tacit complicity or willful ignorance, the office of the Lieutenant Governor has permitted, if not promoted, a legal double standard so grotesque that it offends both reason and law. At San Diego State University, an administrator may call a meeting, cloak it in institutional authority, and forbid the student from bringing a legal advisor. Yet that same administrator may herself be a lawyer, an officer of the court, weaponizing her training while denying the student equal representation. This is not equity. This is not education. This is a kangaroo court. The effect is not merely procedural unfairness. It is a systemic deformation of constitutional guarantees, a bureaucratic sleight of hand, by which the university shields itself from scrutiny, retaliates against dissent, and deprives disabled students of equal protection under law. If the California State University, through its silent coordination with constitutional officers, can engineer proceedings where truth is unwelcome, evidence is made irrelevant, or suppressed, where rights are optional, then let the gavel fall not merely upon this particular injustice, but upon the entire facade of institutional neutrality SDSU pretends to uphold. Let the court not merely read these words, but feel them, as thunder rolling down from Sinai. For when conscience is condemned and darkness proclaims itself light, it is not only law that is wounded, it is liberty herself. Ninth summary of argument. This is not a case born of chaos, but of contradiction. A university that proclaims equity while practicing exclusion, that teaches constitutional law by day, then tramples it by night. SDSU did not merely misapply policy, it inverted principle. In the sacred realm of learning, where conscience should be cultivated and inquiry protected, the plaintiff was punished not for deceit, but for devotion. His essay did not violate the rules, it violated an unspoken orthodoxy, and for that, he was marked. Let it be engraved. The Constitution does not pause at the campus gate, and qualified immunity is not a license for academic officials to act with impunity. It shields lawful discretion, not unlawful reprisal. It protects honest mistakes, not retaliatory persecution dressed in procedural garments. Here, 5 constitutional pillars, intertwined like the columns of Solomon's temple, have been cracked, if not shattered. 1. Procedural due process collapsed under the weight of secrecy and delay. SDSU disregarded its own 40-day rule under Executive Order 1098, withheld notice, denied a hearing, and subverted every safeguard promised by the 14th Amendment. The process was not due, it was deferred, denied, and ultimately destroyed. 2. Substantive due process was defiled when SDSU, without new evidence or complaint, resurrected a quashed case in direct contradiction to the judgment of its own faculty. What had died an official death was reanimated, not by law, but by administrative spite. 3. First Amendment retaliation echoes like a bell no one dared ring. The plaintiff's work, an essay steeped in theology, sincerity, and academic rigor, was not sanctioned for dishonesty, but targeted for dissent. His ideas were not examined, they were condemned. His words were not challenged, they were feared. 4. Equal protection was cast aside like a broken scale. While others were afforded hearings, transparency, and flexibility, plaintiff was ambushed in silence. He was not treated as a student under law, but as an example under threat. The law, once blind, became selective, its sight trained on a lone dissenter. 5. Implied contract and promissory estoppel stand as the gravestones of academic trust. The university extended finality, then exhumed the matter. It offered closure, then reopened the wound. It made assurances, then shattered them, thus breaching the expectations it deliberately created. And over it all hangs the question of qualified immunity, not as a shield of reason, but as a mask for lawlessness. No official is entitled to immunity when constitutional violations are clear, deliberate, and ongoing. Here, the clarity is blinding. Procedural timelines were ignored, disability accommodations denied, retaliatory motives thinly veiled by coincidence, and constitutional protections dismantled in plain view. Qualified immunity does not extend to those who knowingly step outside the law and cloak themselves in titles rather than truth. This case is not about an essay. It is about erosion, the slow, silent bleeding of fairness beneath the robe of formality. It is about precedent, not paperwork, principle, not policy. And if the sword of law is to be sharp, it must first be straight. Let this court be the forge where justice is not only restored, but remembered. 7th argument plaintiff hereby incorporates by reference sections I through 6 of this complaint as though fully set forth herein. Count I, deceptive business practices where law sleeps, let conscience wake a first cause of action, violation of procedural due process, 42 U.S.C. SS 1983. 1. Duty. Under the 14th Amendment and 42 U.S.C. SS 1983, public universities are not merely citadels of scholarship. They are instruments of the state, wielding public power bound by constitutional restraint. Their duty is not academic, it is judicial in nature. They must provide procedural due process before depriving any student of liberty or property interests. That duty is neither decorative nor discretionary. It is eternal, enforced by the courts, and anchored in precedent. Like twin torches lighting the same path, Goss v. Lopez, 419 U.S., 565, 1975, and KJ v. Jackson, 127 F. 4th, 1239, 9th Seer, 2025, confirm what logic and law both demand where student rights are at stake. Process must precede punishment. No public university may bypass that order, not by clever delay, not by administrative euphemism, not by procedural sleight of hand. SDSU codifies this very duty in its governing regulation. Executive Order 1098, which mandates, I, the student conduct administrator, shall promptly investigate each complaint submitted. 2. Investigations shall be concluded within 40 working days after a complaint has been made. These are not suggestions, they are a safeguard. These are not mere guidelines. They are a constitutional floor below which no public institution may fall. 2. Breach. SDSU did not simply err, it rebelled. It did not misstep, It nullified its own legal structure. Without notice, without evidence, and without justification, SDSU resurrected a sealed case, a matter previously quashed by its own faculty, violating not just institutional policy, but constitutional command. No hearing was offered, no timely investigation commenced, no opportunity to respond was meaningfully granted. The 40 working day deadline, crafted specifically to prevent such abuses, was not merely ignored, it was obliterated. The duty to act promptly was betrayed by silence. The responsibility to investigate fairly was replaced with bureaucratic resurrection. SDSU, through Student Conduct Administrator Brianna Brazel, did not investigate promptly. SDSU did not communicate clearly. SDSU did not apply the rule of law. Instead, SDSU waited in calculated stillness until exactly 1 year after a federal OCR complaint had been acknowledged, and only then did she strike, not with facts, but with pretext. This was no administrative oversight. It was a willful breach of duty, committed by those entrusted with power and cloaked in the illusion of process. And where public officials abandon their duties so brazenly, qualified immunity must not shield them from accountability, as discussed in Hope v. Pelzer, 536, U.S. 730, 2002. 3. Causation and damages. From this institutional betrayal flowed bitter fruit, tangible, personal, and profound. The plaintiff suffered emotional distress not as a passing affliction, but as a wound etched into memory. The harm to his reputation is not merely speculative. It is indelible, like ink spilled across a sealed transcript. What should have been a season of peace became a season of torment. Graduation was not a celebration. It was endured beneath a sword of anxiety, an invisible weight pressing against the chest like an unrelenting stone. The damage did not end with abstractions. Plaintiff broke out in hives. His military-acquired post-traumatic stress disorder was aggravated, triggered by the very institution sworn to foster learning and protect rights. Sleepless nights followed. Confidence eroded. The pillars of trust, once built through hard-won resilience in combat, crumbled under the weight of domestic injustice. This was not accidental. SDSU operates by an unwritten rule: protect the institution at all costs, no matter the cost to its students. Its policies are not interpreted, they are manipulated. Its processes are not followed, they are reshaped to suit its objectives. Procedure becomes pretext. Due process becomes delay. Law becomes Pan's Labyrinth, designed not to lead to justice, but to exhaustion. And in the face of this machinery, the plaintiff was made to feel small, not simply overwhelmed, but stripped of agency. Like a mouse trapped in the gears of a merciless machine, he was left feeling helpless, humiliated, and unheard. Not because he lacked truth, not because he lacked law, but because he was silenced beneath the weight of a system that placed protection of image above protection of rights. Let it be stated plainly, this damage is not imaginary. It is psychological, reputational, physical, and constitutional. And it was not inflicted by fate, but by the deliberate, knowing choices of those who abandoned their duty to justice. 4. Conclusion. A public university is bound by a simple covenant: extend to every student the full measure of procedural due process. At San Diego State University, that promise is codified in Executive Order 1098, which requires a prompt investigation, and in no event, more than 40 working days from complaint to decision. That timeline is not a courtesy, it is the constitutional shield that guards students from arbitrary power. SDSU first withdrew that shield, ignoring its own deadline, concealing notice, and denying a meaningful hearing, then wielded its delay as a sword against the plaintiff. By transforming process into pretext, the university trampled the 14th Amendment's guarantee of due process and equal protection, and punished protected expression in violation of the First Amendment. The Constitution does not yield to campus convenience. Where an institution abandons its legal duty, liability must follow. Accordingly, SDSU must be held to account, both to remedy the wrongs suffered here and to reaffirm that no public entity may cloak retaliation in the vestments of procedure and walk away unchallenged. 5. Wherefore, plaintiff respectfully prays that this honorable court, as sentinel of liberty and guardian of constitutional restraint, enter judgment in his favor on this first cause of action and decree the following relief. I. A declaratory judgment declaring that defendants, acting under color of state law, violated plaintiff's rights under the 14th Amendment and 42 U.S.C. SS 1983 by 1. Failing to provide timely notice and a prompt, fair investigation. 2. Reopening a closed matter in violation of both institutional policy and constitutional norms. 3. Denying plaintiff a meaningful opportunity to respond prior to administrative action. Injunctive relief, ordering San Diego State University to 1. Expunge any records, communications, or investigatory materials referencing the improperly reopened academic case. 2. Refrain from further retaliatory or suppressive actions against plaintiff related to the subject matter of this dispute. 3. Restore plaintiff's academic standing to its pre-investigation status, free of notation, stigma, or obstruction. 2. Compensatory damages in an amount to be proven at trial for 1. Emotional distress and mental anguish. 2. Reputational harm. 3. Physical symptoms and exacerbation of diagnosed PTSD. 4. Disruption of postgraduate plans, including delay in LSAT preparation and law school admissions. I for punitive damages, where permitted by law, to condemn the willful indifference and calculated institutional malice exhibited by defendants and to deter future abuse of discretion clothed in policy. V. Attorney's fees and costs, pursuant to 42 U.S.C. SS 1988 and all applicable statutes. VI. Such other and further relief as this court deems just, proper, and necessary, not merely for the vindication of this plaintiff, but for the reaffirmation that due process is not a luxury of power, but the lifeblood of liberty. B. Second cause of action, violation of substantive due process. 42. Abaces, there are policies, and then there is justice. Substantive due process requires more than ritual adherence to form. It demands that the conduct of state actors not shock the conscience. In County of Sacramento v. Lewis, 523 U.S. 833, 1998, the Supreme Court sounded a warning. When governmental authority becomes arbitrary, the Constitution itself becomes a battlefield. SDSU, as a recipient of state funds and therefore an arm of the state of California, is bound by that command. Its officials must steer their discretion within the boundaries of fundamental fairness. They may discipline, but they must never degrade. They may enforce policy, but they must never trample dignity. Anything less offends the very idea of ordered liberty. 2. Breach. SDSU did not act from ignorance. It acted from calculated indifference, cloaking retaliation in the garb of regulation. It overrode the judgment of the course professor, shattering the finality of a resolved matter, and reanimated a dead case without lawful cause, without notice, and well beyond the 40 working day limit imposed by its own executive order. This was not a clerical mistake. There was no new evidence, no student complaint, and no procedural justification, only the lingering scent of contempt. But what makes SDSU's actions not just improper, but conscience-shocking is the timing. It waited until plaintiff was on the precipice of graduation, when family invitations had been sent, final projects submitted, and caps prepared for ceremony. Only then did SDSU unsheath its flaming crooked sword, striking not in the interest of justice, but in the hour of maximum vulnerability. The university knows the rhythm of the academic year. It knows students are most burdened in the final weeks. Exams, grades, and ceremonies all converging. It exploits that burden. Just as it times its faculty reviews to this very moment, it timed its retaliation against plaintiff, hoping stress would silence resistance. Such conduct is not only irregular, it is appalling, strategic, and morally unconscionable. When power is used not to protect but to persecute, and when procedure becomes the mask of malice, the Constitution demands accountability. This breach was not incidental, it was engineered, and SS 1983 offers no sanctuary to such cruelty. 3. Causation and damages. What followed was not a mere administrative mishap. It was the slow bleed of institutional betrayal. Plaintiff remains in academic purgatory, not by chance, but by design. A student who should be preparing for the LSAT is instead burdened by uncertainty, trapped in the purgatory of an unresolved disciplinary case. Where closure was owed, chaos was conjured. Where peace was promised, punishment was manufactured. SDSU did not act as a mentor, but as a malicious magistrate, inflicting both psychological and physiological injury. The plaintiff, a disabled veteran and father, suffered severe emotional distress, full body hives, insomnia, anxiety, and an erosion of life's enjoyment. His motivation, once animated by hope, is now paralyzed by fear of future retaliation, academic ambiguity, and reputational harm. But for SDSU's unlawful resurrection of a closed matter, plaintiff would be moving forward, pursuing graduate studies, restoring peace of mind, and reclaiming dignity. Instead, the injury persists. The case remains open, the future remains clouded, and SDSU continues to compound the damage with every day it fails to rectify its misconduct. 4. Conclusion. Let it be declared plainly, state actors may never wield power arbitrarily or engage in conduct that shocks the conscience. That is the command of the Constitution, and SDSU defied it at every turn. It crossed the forbidden line by resurrecting a quashed case on the very anniversary of a federal civil rights complaint. I. It crossed it again by wielding a weaponized process in the midst of graduation, transforming joy into dread. 2. A third time, it crossed that line by treating no evidence as decisive evidence, disregarding both academic judgment and factual record. 2. A fourth time, it breached due process by admitting that undisclosed information, inaccessible to plaintiff, had already been used to pronounce guilt. Each act alone may offend, but together they reveal a pattern, a premeditated defiance of due process, cloaked in institutional formality but soaked in constitutional contempt. Thus, SDSU stands not merely accused of error, but convicted by its own record of conscience-shocking conduct. It has shattered the safeguards of substantive due process. It has used its position not to educate, but to retaliate. And now, it must be judged accordingly, not only by this court, but by the enduring principles it was created to defend. 5. Where conscience is shattered, let justice be reforged. Wherefore, having shown that defendants did not merely err but egregiously abuse the mantle of public trust, plaintiff respectfully prays that this court, arbiter of rights and steward of the Constitution, enter judgment in his favor on this second cause of action, and grant the following relief. I, a declaratory judgment affirming that defendants, acting under color of state law, violated plaintiff's rights under the substantive component of the 14th Amendment by 1. Reopening a closed case without lawful justification, new evidence, or procedural authority. 2. Acting with conscious indifference to plaintiff's protected interests and emotional well-being. 3. Engaging in retaliation cloaked as process at a moment of maximum psychological vulnerability. 2. Injunctive relief, ordering San Diego State University and its agents to 1. Cease and desist all further disciplinary proceedings or references arising from the previously resolved matter. 2. Expunge all notations, memoranda, or digital records indicating that any such case was ever reopened or reconsidered. 3. Institute safeguards to prevent the arbitrary resurrection of quashed academic proceedings, particularly when such acts coincide with protected speech or constitutionally sensitive periods such as graduation. 2. Compensatory damages in an amount to be proven at trial to redress 1. Emotional anguish, physiological harm, and mental trauma sustained by plaintiff. 2. Loss of academic momentum and delay in pursuing graduate education. 3. Reputational damage and disruption of postgraduate peace and planning. Punitive damages to penalize the willful, conscience-shocking conduct of defendants and deter future misuse of institutional power masked in procedural disguise. The attorney's fees and costs pursuant to 42 U.S.C. SS 1988 and all other applicable provisions of law. 5. Such other and further relief as the court may deem just and necessary, not only to remedy the injury of one plaintiff, but to send an unmistakable signal that substantive due process is not an adornment of justice, but its cornerstone, and that where it is trampled, the judiciary must stand as both sword and shield. 1. Duty. The First Amendment is not a decorative footnote to public education. It is the bedrock upon which every classroom stands. A state-funded university may never retaliate against a student for the content of religious, political, or philosophical expression. The Supreme Court made this principle unmistakable in Tinker v. Des Moines, 393, U.S. 503, 1969. Students do not shed their constitutional rights at the schoolhouse gate. This command binds all state actors, including public universities, through the 14th Amendment's Due Process Clause, as first recognized in Everson v. Board of Education, 330 U.S. 1, 1947. In Everson, the court incorporated the Establishment Clause against the states and reinforced the inviolable separation of church and state, holding that public institutions must remain neutral in matters of religion and may not privilege or penalize religious expression. SDSU as an arm of the state of California is therefore not merely encouraged, but constitutionally compelled to protect, not punish, religious speech. California's law echoes that command with equal force. California Civil Code SS 52.1, the Bain Act, imposes liability on any public entity or official who, by threat, intimidation, or coercion, interferes with rights secured by the Constitution of the United States or the laws of California. Thus, SDSU and its administrators carry a dual duty. Federal duty, refrain from punishing protected speech or expressive conduct under the First Amendment. 2. State duty, refrain from using threats, intimidation, or administrative coercion to chill or burden those same rights, on pain of civil liability under SS 52.1. In short, the university is not merely encouraged but constitutionally and statutorily compelled to protect, rather than persecute, the very speech it exists to foster. 2. Breach. Plaintiff's paper was not plagiarism, it was prophecy. It was religious in tone, spiritual in force, and unmistakably sincere. Yet despite the professor's conclusion that no misconduct occurred, SDSU revived the case solely because of the message. There was no dishonesty, only conviction. No fraud, only faith. 3. Causation and damages. What followed was not legitimate scrutiny, but calculated censure by proxy, an act of bureaucratic vengeance wrapped in educational formality. Plaintiff endured emotional distress that pierced deep into his psyche, reputational damage that no transcript can amend, and a chilling effect that may silence future expressions of conviction. The cost was not abstract. It was sleepless nights, public humiliation, and the internalized warning that truth must be whispered, never shouted. The university's message resounded with menace: speak boldly and suffer quietly. Defendants may attempt to invoke the Mount Healthy defense, arguing that any adverse actions taken against plaintiff were based on legitimate academic concerns rather than retaliatory intent. But under the burden-shifting framework articulated in Mount Healthy City School District Board of Education v. Doyle, 429 U.S. 274, 1977, once a plaintiff shows that 1. He engaged in constitutionally protected conduct. 2. He suffered an adverse action. And 3. The protected conduct was a substantial or motivating factor behind the adverse action. The burden shifts to the defendant to prove, by a preponderance of the evidence, that it would have taken the same action regardless of the protected conduct. 4. Here, plaintiff satisfies each element. A. He submitted a religiously expressive essay. B. He was subjected to a reopened disciplinary process, loss of accommodations, and reputational harm. The timing, coinciding with his graduation and following a civil rights complaint, along with the complete absence of new evidence, raises a compelling inference of retaliatory motive. D. Defendants cannot meet their burden. The university's deviation from its own policies, the calculated silence surrounding the investigation, and the selective application of disciplinary scrutiny all point to one truth: plaintiff was not punished for dishonesty. He was punished for daring to speak. 4. Conclusion. Public institutions may not retaliate against religious or philosophical expression, not in silence, not in subtext, and not through procedural camouflage. When SDSU turned a religious essay into a trigger for punishment, it crossed the sacred boundary between education and inquisition. The Constitution demands more. Thus, SDSU did not merely err. It violated the First Amendment and now must be summoned to the altar of accountability, where truth is not punished, but vindicated. Public institutions may not retaliate against religious or philosophical expression, not in silence, not in subtext, and not through procedural camouflage. When SDSU turned a religious essay into a trigger for punishment, it crossed the sacred boundary between education and inquisition. The Constitution demands more. As the Supreme Court declared in Everson v. Board of Education, 330 U.S. 1947, when it first applied the Establishment Clause to state entities, the First Amendment has erected a wall between church and state. That wall must be kept high and impregnable. That wall was not built to silence faith. It was built to protect it from state interference, ensuring that students of every creed may speak without fear. SDSU did not merely ignore this principle, it trampled it. When a student is punished for religious conviction, the university ceases to be a school of thought and becomes a tribunal of persecution. Thus, SDSU did not merely err, it violated the First Amendment and must now be summoned to the altar of accountability, where truth is not punished but vindicated. 5. Relief sought where truth is chained, let the law set it free. Wherefore, having shown SDSU did not merely suppress expression, but punished it, that it did not merely regulate speech, but retaliated against its sacred exercise, plaintiff respectfully prays that this court, sentinel of liberty and tribunal of last redress, entered judgment in his favor and decree the following relief. I, a declaratory judgment affirming that defendants, acting under color of state law, violated plaintiffs' rights under the First Amendment to the United States Constitution and California Civil Code SS 52.1 by 1. Retaliating against the plaintiff's religious expression, despite a faculty determination of no misconduct. 2. Employing administrative coercion to chill constitutionally protected speech. 3. Subjecting the plaintiff to ongoing scrutiny and investigation based solely on the content of his expressive work. 2. Injunctive relief, compelling San Diego State University to 1. Permanently expunge all records, emails, or internal references indicating that plaintiff's essay was the subject of misconduct allegations or review. 2. Cease and desist all present or future actions that burden, penalize, or stigmatize the plaintiff's protected religious, political, or philosophical expression. 3. Affirm publicly that religious and expressive rights are fully protected under university policy and constitutional law, including within academic submissions. 2. Compensatory damages in an amount to be proven at trial for 1. Emotional anguish and psychological suffering endured by plaintiff. 2. Reputational harm and damage to academic standing. 3. The chilling effect imposed upon plaintiff's future expressive conduct and academic endeavors. 4. Punitive damages to condemn and deter SDSU's willful indifference to constitutional mandates and its calculated retaliation against protected speech, a message that public power shall never again be weaponized against personal faith. V. Statutory damages and attorney's fees, pursuant to California Civil Code SS 52.1 and 42 U.S.C. SS 1988, for the vindication of civil rights secured by both state and federal law, vi. And such other and further relief as this court deems just and proper, not merely to restore one student's dignity, but to reaffirm the uncompromising principle that the classroom is not a courtroom and faith is not a fault. Where universities deviate from that foundation, courts must stand firm and unflinching, restoring what was silenced and redeeming what was unjustly condemned. The fourth cause of action, violation of equal protection, 42 U.S.C.S.S. 1983. 1. The Equal Protection Clause was forged to restrain power from playing favorites and to ensure that the law's scales never tip by whim or prejudice. As the Supreme Court declared in Village of Willowbrook v. Olek, 528 U.S. 562, 2000, even a lone plaintiff, a class of one, is entitled to constitutional sanctuary when government actors mete out arbitrary and irrational treatment. 2. Breach. Plaintiff was not the only student whose work bore hints of artificiality or ambiguity, yet he alone felt the university's blade. Where others received timely notice, transparent hearings, and remedial grace, plaintiff encountered silence, secrecy, and summary punishment. He was singled out not for conduct but for conviction, treated as an offender while similarly situated classmates were spared. In choosing its target, SDSU replaced the principle of equality with the practice of discrimination. 3. Causation and damages. This double standard carved wounds deeper than mere procedural error. It broadcast a chilling decree: your beliefs are unwelcome, your voice too perilous. The immediate damage is legal, an unwarranted blemish on plaintiff's record, but the deeper harm is moral disfigurement. Trust in institutional fairness has been shattered. Future opportunities clouded, the promise of equal citizenship within the academic community broken. 4. Conclusion. Equal protection demands even-handed justice. SDSU abandoned that sacred balance, elevating caprice above consistency and wielding punishment as a tool of preference. By treating plaintiff unlike his peers without rational basis, the university violated the Equal Protection Clause. Restoration, both of record and of right, must follow. 5. Where equality has been betrayed, let restoration be complete. Wherefore, having shown that San Diego State University wielded its authority unevenly, shielding some, striking one, and thereby fractured the very promise of the Equal Protection Clause, plaintiff respectfully prays that this court, keeper of the balance and guardian of impartial justice, enter judgment in his favor on this fourth cause of action and order the following relief. I. A declaratory judgment proclaiming that defendants, under color of state law, violated the Equal Protection Clause of the 14th Amendment by 1. Singling out plaintiff for disparate and harsher treatment without rational justification. 2. Denying plaintiff procedural safeguards routinely afforded to similarly situated students. 3. Employing arbitrary criteria, anchored in viewpoint, not conduct, to determine disciplinary severity. Sit. Injunctive relief, compelling San Diego State University to 1. Expunge every notation, database entry, or report that reflects the unequal disciplinary action taken against plaintiff. 2. Adopt and implement uniform, published standards to ensure that future allegations of academic misconduct are investigated and resolved, without favoritism or prejudice. 3. Submit to this court, within 60 days, a certification of compliance outlining the steps taken to guarantee equal protection for all students going forward. 2. Compensatory damages, in an amount to be proven at trial, to redress 1. The reputational scar left upon plaintiff's academic record. 2. The emotional distress and anxiety produced by discriminatory punishment. 3. The concrete loss of educational and professional opportunities resulting from SDSU's unequal treatment. I. Punitive damages, sufficient to punish and deter defendants' deliberate departure from constitutional neutrality, and to remind every public official that equality is a mandate, not a mood. versus attorney's fees and costs pursuant to 42 U.S.C. SS 1988 to ensure that vindication of equal protection is not thwarted by the burden of its pursuit. Such other and further relief as this court deems just and equitable, so that the lesson written in this judgment is unmistakable. Where state actors tilt the scales, the judiciary must set them right, lest equal protection become an ornament instead of an oath. Fifth cause of action, breach of implied contract promissory estoppel, state law, supplemental jurisdiction, under 28 U.S.C. SS 1367. 1. Duty. When a university publishes procedures, issues accommodations, and invites reliance, it forges more than policy. It forges a covenant of trust. California law recognizes this bond, Zumbrun v. USC, 25 Cal. App. Thap 3D1, 1972, holds that an institution may not offer certainty and then deliver chaos. SDSU entered two interlocking promises. Procedural promise. Executive Order 1098 guarantees that every misconduct investigation will be completed within 40 working days. 2. Disability accommodation contract. On May 19, 2023, SDSU issued a formal accommodation letter expressly authorizing the plaintiff to employ assistive technologies AI in all coursework, an offer of support upon which the plaintiff was entitled to rely. These assurances are not optional guidelines, they are implied contracts, binding in both law and equity. 2. Breach. SDSU invited reliance, then shattered it. It published the 40-day timeline, then let the clock expire in silence. It promised lasting disability accommodations, then weaponized the very use of AI as an act of alleged misconduct. The course professor formally quashed the matter. The university itself remained mute, until day's hearing date, time, courtroom. Before graduation, it resurrected the case and stripped away the promised accommodations. Thus, SDSU breached not one, but both implied contracts, the procedural covenant and the disability covenant. 3. Causation and damages. The consequences were immediate and profound. Plaintiff's postgraduate prospects, including LSAT preparation, collapsed under renewed accusations. His reputation was clouded, his mental health battered, and the promised security of disability accommodations torn away. But for SDSU's broken promises, plaintiff would have advanced unimpeded. Instead, he stands halted, wounded by an institution that pledged protection yet delivered persecution. 4. Conclusion. Institutions must honor the promises they proclaim. SDSU pledged procedural finality and disability support, then abrogated both. In conscience and in contract, that breach demands redress. Accordingly, SDSU is liable for the injuries its broken word has wrought and must restore what it so recklessly destroyed. 5. Where promises are broken, let equity repair the ruins. Wherefore, having shown that SDSU transformed published assurances into shifting sand, inviting reliance only to revoke it, plaintiff respectfully prays that this court, wielding both the scales of law and the sword of equity, enter judgment in his favor on this fifth cause of action, and order the following relief. Declaratory judgment affirming that 1. Executive Order 1098's 40-day deadline and plaintiff's May 19 accommodation letter constitute enforceable implied contractual terms. 2. Defendants breached those terms by reviving a quashed investigation, ignoring the 40-day safeguard, and weaponizing approved assistive technologies against the very student they were meant to empower. 2. Injunctive relief compelling San Diego State University to 1. Reinstate in full the original disability accommodations, expressly including AI-based tools for academic and professional use. 2. Expunge every notation, email thread, or internal memorandum that contradicts or impugns those accommodations, or suggests the reopened disciplinary action ever carried legal force. 3. Certify compliance to this court within 30 days, detailing procedural reforms that ensure timely investigations and protect the sanctity of accommodation letters henceforth. 4. Compensatory and consequential damages, in an amount to be proven at trial, for A. Lost study time and delayed LSAT preparation. B. Emotional distress, mental health treatment, and physical manifestations of stress. C. Reputational injury and diminished graduate school prospects, flowing directly from SDSU's contractual breach. 5. Expectancy and reliance damages, to place plaintiff in the precise academic and professional position he would have occupied had SDSU honored its promises, instead of betraying them. 6. Attorney's fees and costs, pursuant to California Code of Civil Procedure SS 1021.5 and any other applicable authority, so that the cost of vindicating reliance does not eclipse the right itself. 7. such other and further relief as this court deems just, proper, and equitable, to declare to every California student that a university's promise is not a paper shield but a binding pledge, and that when a public institution sows chaos after offering certainty, equity will harvest justice. F6th cause of action violation of Title II of the Americans with Disabilities Act 42, USC SS 12132, supplemental jurisdiction under 28 USC SS 1367. 1. Duty. When a public university opens its gates, it does so under the bright banner of Title II of the Americans with Disabilities Act. That banner is more than decoration. It is a covenant of complaint hearing date, time, courtroom, -33, equal access. No qualified individual with a disability shall, by reason of such disability, be excluded from participation in or be denied the benefits of the services, programs, or activities of a public entity. 42 USC SS 12132. San Diego State University is indisputably a public entity. Plaintiff is a qualified individual, formally recognized by SDSU's own disability services on May 19, 2023, when the university issued a written accommodation letter authorizing permanent full use of assistive technology, including AI tools. These assurances were not suggestions, they were statutory obligations clothed in university letterhead. 2. Breach. SDSU invited reliance, then reversed course. It published and honored those accommodations throughout the semester until retaliatory zeal demanded a different narrative. 2. It then weaponized the very AI accommodation it had granted, labeling its use misconduct, when plaintiff, acting as sole caregiver, sought a modest rescheduling of an unilaterally set conference. Thursday therapy conflicted, Friday sufficed. The university refused even to respond. 4. Finally, during the resurrected disciplinary gauntlet, SDSU stripped away all assistive tools, demanding an essay written without the aids every other student was free to employ. Each act, denial of approved tools, refusal to reschedule, punitive revival of a quashed case, exiled plaintiff from equal participation. That is not oversight, it is discrimination by design. 3. Causation and damages. The chain of harm is direct and unbroken. SDSU's denial of accommodations and retaliatory use of them as misconduct. 1. Halted plaintiff's LSAT preparation, imperiling a legal career, painstakingly planned. 2. Aggravated PTSD triggering full-body hives, insomnia, and debilitating anxiety. 3. Diminished reputation, casting doubt on academic integrity precisely when graduate applications demand pristine standing. 4. Chilled future self-advocacy, teaching that asserting disability rights invites institutional reprisal. But for SDSU's breach, plaintiff would stand poised for professional advancement. Instead, he stands paralyzed beneath the cloud entirely of the university's making. 4. Conclusion. Title II is a shield, not a trinket. SDSU shattered that shield, converting promised accommodation into prosecutorial cudgel and equal access into exclusive ordeal. In law and in equity, the university is liable for every ripple of injury. Emotional, reputational, academic, its unlawful discrimination set in motion. Accordingly, plaintiff seeks declaratory judgment that SDSU violated Title II. 1. Injunctive relief restoring all accommodations and barring any future retaliation. 2. Compensatory damages for emotional distress, lost educational opportunity, and related economic loss. 3. Attorney's fees and litigation costs under 42 USCSS 12205. And 4. Such further relief as this court deems just, to ensure that equal access is not an empty promise, but a living guarantee. Institutions that promise inclusion must practice it. When they do not, the ADA answers, and this court must likewise let justice speak. G. 7th cause of action. Violation of Section 504 of the Rehabilitation Act of 1973. 1. Duty. Under Section 504 of the Rehabilitation Act, any institution receiving federal financial assistance may not exclude, deny the benefits of, or discriminate against an individual with a disability solely by reason of that disability. SDSU, as a recipient of federal funds, is thus held to this standard not merely as policy, but as binding federal mandate. Plaintiff, formally recognized as disabled and in receipt of documented accommodations since May 19, 2023, falls squarely within the protected class. SDSU's obligation was plain. It owed plaintiff meaningful access, non-discriminatory participation, and equal treatment throughout his academic experience. 2. Breach. I. Rather than uphold the statutory duty, SDSU used plaintiff's disability as a pretext to punish. 2. The university explicitly approved the use of AI-based assistive technology for all assignments. 2. Yet it later cited that very usage is suspicious, opening a secret investigation premised not on misconduct, but on accommodation. I-4. Further, when plaintiff requested a simple rescheduling of a disciplinary meeting due to therapy commitments, an accommodation SDSU had previously granted, it refused without justification. V. Most egregiously, SDSU revoked his disability tools in a coerced sanction essay, demanding a demonstration of guilt under conditions from which all others were exempt. These actions constitute a clear breach of Section 504, as they denied plaintiff full and fair participation solely due to his disability and its corresponding accommodations. 3. Causation and damages. The causal chain is not speculative, it is stark and substantiated. SDSU's conduct. I impacted academic trajectory, leaving plaintiff in unresolved disciplinary limbo, unable to finalize graduate plans. 2. Exacerbated existing mental health diagnoses, including service-related PTSD, now inflamed by institutional betrayal. 2. Induced physical ailments, including chronic stress responses, loss of sleep, and full-body hives. 4. Created reputational harm, casting doubt on academic integrity at a crucial juncture in plaintiff's professional development. Had SDSU honored its Section 504 duties, none of these injuries would have materialized. 4. Conclusion. Section 504 was enacted to prevent precisely this type of institutional ambush, the betrayal of a student's trust in the very supports designed to ensure equal opportunity. SDSU received federal funds with full knowledge of its obligations, and then wielded those obligations as weapons of exclusion. For this, plaintiff seeks I declaratory judgment that SDSU violated Section 504, SECU, injunctive relief requiring immediate restoration of all accommodations and prohibition of further discriminatory acts. 2. Compensatory damages for emotional, physical, and academic injury directly resulting from SDSU's breach. IV. Attorney's fees and litigation costs pursuant to 29 U.S.C. SS 794A, and V. All such further relief as justice may demand to reaffirm the principle that disability is not a disqualifier and accommodation is not misconduct. VI. Declaratory judgment that SDSU violated Title II. 70. Injunctive relief restoring all accommodations and barring any future retaliation. 7. Compensatory damages for emotional distress, lost educational opportunity, and related economic loss. IACAS. Attorney's fees and litigation costs under 42 U.S.C. SS 12205, and such further relief as this court deems just, to ensure that equal access is not an empty promise, but a living guarantee. Institutions that promise inclusion must practice it. When they do not, the ADA answers, and this court must likewise let justice speak. 8th cause of action. Retaliation under Section 504 of the Rehabilitation Act, 1973-29, U.S.C. SS 794, 34 CFR, SS 104.61, incorporating 34 CFR, SS 100.7E, supplemental jurisdiction under 28 U.S.C. SS 1367. 1. Duty. Federal law forbids not only discrimination on the basis of disability, but retaliation against those who assert their right to be free from such discrimination. Under Section 504 and its implementing regulations, SDSU, as a federally funded institution, had a non-negotiable duty to refrain from punishing any student for exercising disability-related rights. Plaintiff, a disabled veteran and accommodated student, did exactly what the law envisioned. He requested disability accommodations. 1. He relied upon them in his coursework. 2. And he later sought enforcement of those rights when SDSU tried to covertly remove them. This created a protected activity. The university, in turn, had a corresponding duty to ensure that no reprisal followed. 2. Breach. SDSU did not merely fail in this duty, it retaliated in open defiance of it. Upon learning that plaintiff used AI-based assistive technology explicitly authorized by the Disability Office, SDSU launched a misconduct investigation under cover of silence. 2. After the professor quashed the matter, SDSU reopened it without notice, conveniently timed near plaintiff's graduation. 2. When plaintiff protested, requested accommodations, and sought resolution, SDSU demanded submission, forced forfeiture of his assistive tech, and imposed sanctions contingent on surrender. Even after his graduation, SDSU refused to close the case, effectively chilling plaintiff's academic record and professional momentum. These actions were not neutral. They were causally connected to plaintiff's assertion of rights. Retaliation, in both tone and timing, poisoned every procedural step thereafter. 3. Causation and damages. The harm to plaintiff was not speculative. It was causally tethered to his assertion of disability rights. I. Emotional injury, including distress, humiliation, and the deep psychological toll of being targeted for protected conduct. 2. Physical reactions, including full body hives, sleep loss, and increased PTSD symptoms. Educational harm, with the threat of unresolved sanctions hanging like a noose over plaintiff's ability to pursue legal studies. IV. Reputational injury, with unresolved allegations clouding what should have been a celebratory transition from student to graduate. But for SDSU's retaliation, these harms would not have occurred. They stem directly from plaintiff's protected activity. 1. Defendants may attempt to argue that the adverse actions taken against plaintiff, reopening a closed case, stripping accommodations, and coercing compliance, were based on legitimate academic concerns. But the Rehabilitation Act, through its implementing regulation at 34 CFR SS 100.7E, incorporates a burden-shifting framework analogous to Mount Healthy. Once plaintiff shows A. He engaged in a protected activity, namely requesting and asserting rights to disability accommodations. B. He suffered adverse actions, including a secret investigation, the revocation of accommodations, and retaliatory procedural targeting. And there is a causal link between the protected activity and the adverse action. The burden shifts to defendants to prove, by a preponderance of the evidence, that the same actions would have been taken absent plaintiff's protected conduct. D here, plaintiff has met and exceeded that threshold. I. He was a registered disabled student with written accommodations. 2. He relied on those accommodations, then was punished for using them. 2. No other student faced scrutiny for AI-related work, and the case was only reopened after plaintiff filed a civil rights complaint and challenged anti-Semitic speech on campus. The timing is damning, the record is barren of legitimate rationale, and the university's deviation from policy, silence toward accommodation requests, and use of process as punishment cannot be explained away by neutral justification. Therefore, defendants must carry the burden, and they cannot. The retaliation was not incidental. It was targeted, timed, and tied directly to plaintiff's assertion of rights. The law provides no refuge for such reprisal. 4. Conclusion. Retaliation under Section 504 is not an abstract wrong. It is a statutory offense, a breach of civil obligation, and a betrayal of moral duty. SDSU knew of plaintiff's disability. It approved his accommodations. It then turned those tools into targets, and those rights into risks. Such conduct chills not just one voice, but the confidence of every student seeking help. 5. Therefore, plaintiff seeks I. Declaratory judgment that SDSU violated anti-retaliation provisions under Section 504. Q. Injunctive relief preventing SDSU from further retaliation or coercion against plaintiff. 2. Compensatory damages for physical, emotional, academic, and reputational harm. IV. Attorney's fees and costs under 29 U.S.C. SS 794 AB. Any further relief this court deems just to reaffirm that accommodation is not provocation, and the assertion of rights must never be punished. Ninth cause of action. Violation of the UNRRA Civil Rights Act. California Civil Code, SSSS 51-52. Supplemental jurisdiction under 28 U.S.C. SS 1367. 1. Duty. The UNRRA Civil Rights Act commands that every business establishment, including a publicly funded university, must provide full and equal accommodations, advantages, facilities, privileges, or services to all persons, regardless of disability or religion. San Diego State University, open to the public and recipient of state funds, squarely fits the Act's definition. Plaintiff, a disabled veteran whose coursework expressed religious conviction, is a protected individual under both categories. 2. Breach. Unequal adverse treatment that lacks a rational basis constitutes discrimination under UNRRA. SDSU isolated plaintiff for harsher treatment. I singled out his AI-assisted work while excusing similarly situated classmates. 2. Reopened a quashed file against him alone. 2. Stripped promised accommodations available to every other student. I targeted his religiously infused assignment for secret scrutiny. No legitimate religion or disability-neutral rationale justifies this disparity. Therefore, SDSU breached its statutory duty of equal access and treatment. 3. Causation and damages. UNRU provides statutory damages of no less than $4,000 per violation, plus actual damages and emotional distress recovery. SDSU's discriminatory acts caused I. Economic injury, delayed LSAT, lost application cycles. 2. Reputational harm, clouded academic record. 2. Emotional and physical distress, PTSD aggravation, hives, sleeplessness. Therefore, each discriminatory act triggers statutory and compensatory damages. 4. Conclusion. The UNRU Act is California's civil rights bulwark. It permits no exceptions for ivory towers draped in red tape. SDSU substituted bias for balance and zealotry for zero-tolerance equality. 5. Accordingly, plaintiff prays for I. Declaratory judgment that SDSU violated the UNRU Civil Rights Act. 2. Statutory damages of not less than $4,000 per discriminatory act, plus all proven actual damages. 2. Injunctive relief compelling SDSU to cease discriminatory practices and restore plaintiffs' equal standing, IV attorneys' fees and costs under Cal. C of Code SS 52BV. Such other and further relief as equity demands, to proclaim that in California's halls of learning, equality is not elective, it is enforced. J. 10th cause of action, hostile environment discrimination and viewpoint suppression. Title VI of the Civil Rights Act, 42 U.S.C. SS 2000D, Equal Protection and First Amendment via 42 U.S.C. SS 1983. 1. Duty. Equality is a constitutional and statutory imperative. Public universities do not merely instruct, they govern. Because San Diego State University SDSU receives federal funds, Title VI obliges it to operate without discrimination on the ground of race, color, or national origin. 42 U.S.C. SS 2000D. The Supreme Court has long recognized that anti-Jewish animus falls within that rubric. Sha'arei Tefillah Congregation v. Cobb, 481 U.S. 615, equal the concurrent. First Amendment forbid any state actor from favoring one political or religious viewpoint while burdening another. See Rosenberger v. Rector and Visitors of Univ. A VA, 515 U.S. 819 1995. Davis v. Monroe, CNTUI. Juke, 526. U.S. 629. Hostile are deliberately indifferent. These mandates are not ceremonial, they are non-delegable. A university must I. prevent hostile or threatening environments aimed at protected classes, and tie. Remain viewpoint neutral in official forums such as commencement exercises. 2. Breach. Sanctioning partisan propaganda. Silencing dissent on May 16, 2025, SDSU conferred official blessing on a commencement address that I. portrayed Israel, a United States ally, as a genocidal aggressor, omitting any reference to the October 7 terrorist massacre, the 1,200 Israeli dead, or the 56 hostages who, on that very day, remained in Hamas captivity. 2. Ignored public evidence that Qatari humanitarian funds were diverted to Hamas armaments. I.U. offered no acknowledgement of American support for Israel or of Israel's protective measures for Gaza civilians. 4. Branded pro-Israel students and faculty as moral pariahs, inviting peers to choose a side. By featuring this speech without even minimal balance, SDSU endorsed a narrative that demonized Jewish identity and chilled pro-Israel expression. Jewish graduates, including plaintiff and fellow student Liz, felt physically unsafe, emotionally harassed, and compelled to leave the ceremony early. Administrators were alerted to the danger yet remained deliberately indifferent, satisfying the Davis standard for institutional liability. 3. Causation and damages. Concrete harms from official hostility, emotional and physical injury. Plaintiff's military-related PTSD was sharply aggravated, hives and insomnia ensued. I. Educational and reputational harm. Forced exit from his own graduation marred an academic milestone, undermined prospective references, and stained his honors with suspicion. 2. Chilling of protected speech. Plaintiff now self-censors on Jewish and geopolitical issues for fear of retaliation, an actionable First Amendment injury. 2. Danger of violence. SDSU's endorsement of one-sided rhetoric foreseeably emboldened radical responses, placing both Jewish and Muslim students in jeopardy. These wounds are neither abstract nor speculative. They are the traceable proximate result of SDSU's discriminatory and viewpoint selective act. 4. Conclusion. When the academy becomes the inquisitor, a university that hoists propaganda over principle, forfeits the cloak of neutrality. By sponsoring anti-Semitic, anti-American rhetoric at a mandatory cap-and-gown rite of passage and by ignoring the predictable harms to a protected minority. SDSU violated Title VI, the Equal Protection Clause, and the First Amendment in a single stroke. This is not merely a lapse in discretion, it is a breach of constitutional architecture. The Supreme Court made clear in Everson v. Board of Education, 330 U.S. 1 1947, that the First Amendment's Establishment Clause binds state actors through the 14th Amendment's Due Process Clause. In Justice Hugo Black's enduring words, "The First Amendment has erected a wall between church and state. That wall must be kept high and impregnable. That wall is not ornamental, it is foundational." And SDSU, by promoting one worldview at a public ceremony while allowing the marginalization of Jewish students, breached that wall in spirit and in substance. It placed state power behind partisan messaging, then ignored the voices of those it endangered. As Rosenberger for Rector 515 U.S. instructs, state-sponsored speech must remain viewpoint neutral when it is not. Constitutional injury is presumed. Liberty limps wherever such partisanship is enthroned under color of state law. Liability must therefore follow, not merely for the sake of this plaintiff, but to prevent universities from turning commencement into a crucible of exclusion. Constitutional interlock with the First Amendment retaliation claim. This 11th cause of action does not stand alone. It is inextricably linked to the First Amendment retaliation claim set forth in plaintiff's third cause of action, where SDSU used its graduation stage to exalt partisan messaging that demonized a protected religious identity. It did more than foster a hostile environment. It laid the predicate for retaliation. Plaintiff's subsequent expression, through written objection, civil rights complaints, and private religious work, was not honored, it was hunted. That retaliation, detailed fully in the First Amendment claim, was not a separate wrong but a second strike from the same constitutional wound. Together, these claims reveal a coordinated pattern. State power first sponsored political hostility, then wielded administrative machinery to punish dissent from that hostility. Thus, this court should read these causes not as isolated skirmishes, but as a single structure of constitutional injury, a wall breached in public and truth punished in private. The remedy must be as comprehensive as the violation. 5. Wherefore plaintiff respectfully prays that this court, I declare that defendants, acting under color of state law, violated Title VI, the Equal Protection Clause, and the First Amendment by A, endorsing hostile political speech that targeted Jewish students, B, acting with deliberate indifference to the resulting harassment, and C, chilling the protected expression of plaintiff and similarly situated students. Second, enjoin SDSU to 1. Issue a public statement repudiating the May 16, 2025 speech and reaffirming its duty of viewpoint neutrality. 2. Adopt and enforce content-neutral commencement guidelines that protect all students from discriminatory or hostile messaging. 3. Provide mandatory anti-Semitism awareness training for commencement planners and senior administrators. 4. Award compensatory damages for emotional distress, physical manifestations of PTSD aggravation, reputational harm, and lost educational and professional opportunities in an amount to be proven at trial. Award punitive damages under SS 1009-83 against individual administrators whose deliberate indifference or animus fomented the hostile environment. 6. Award attorneys' fees and costs pursuant to 42 U.S.C. SS 1988 and any other applicable statute. 7. Grant such further relief, legal or equitable, as justice, equity, and the preservation of constitutional liberty require. Thus let it be recorded, where a public university turns commencement into a crucible of prejudice, the Constitution itself becomes the valedictorian, reciting the timeless lesson that government-sponsored discrimination shall not stand. No final disciplinary sanction was imposed. 1. SDSU's likely argument: due process protections do not apply because no disciplinary record was created, no diploma was withheld, and no formal penalty was imposed. 2. Rebuttal: this is sophistry veiled as defense. The Constitution does not wait for the guillotine to fall before it raises its shield. Due process is not reserved for the executed, it is the right of the accused. In Matthews v. Eldridge, 424 U.S. 319, 1976, the court made plain, due process attaches the moment a protected interest is placed at risk, not merely when it is taken. Plaintiff was placed under secret investigation. He was denied notice. He was stripped of the opportunity to speak on his own behalf. Just days before his graduation, his name was cast into shadow, his future held hostage by the silent judgment of bureaucrats. This is not hypothetical harm. It is reputational injury, constitutional erosion, and emotional injury rolled into one. In Goss v. Lopez, 419 U.S. 565, even a brief suspension triggered. Here, the plaintiff's entire academic standing was endangered, not by action, but by threat cloaked in silence. And let it be clear, the absence of a final blow does not absolve the swing of the sword. B. Reopening the case was routine academic discretion. 1. SDSU's likely argument. Reopening the case was a good faith academic decision, not conscience shocking. Substantive due process only applies to egregious violations. 2. Rebuttal. This too collapses under its own contradiction. What SDSU calls routine is in truth the ritual of institutional infidelity. Substantive due process is indeed reserved for egregious conduct. But what could be more egregious than violating your own law, overturning your own closure, and crucifying your own faculty's judgment? County of Sacramento versus Lewis, 523 U.S. 833 1998, teaches that when public actors abandon their own rules, when they trample settled expectations in the name of faceless authority, their actions become conscience-shocking. And so it is here. In Hope v. Pelzer, 536 U.S., the Supreme Court 2002, the Supreme Court taught that when government actors inflict harm that is obvious in its constitutional offense, no cloak of discretion or procedural haze can shield them. The guard's decision to strap Larry Hope to a hitching post, without penological purpose and in callous disregard of basic human dignity, was so arbitrary, purposeless, and cruel that it stripped the officials of qualified immunity. The Constitution stirred at once. Precedent need not be a prisoner of identical facts. So too here. San Diego State University published a 40-day deadline, promised procedural finality, accepted the faculty's case closed, and then, without new evidence, notice, or lawful cause, raised the dead file to life. That is not the measured exercise of academic discretion. It is the same unnecessary and wanton betrayal of law and conscience that Hope condemns. The Constitution, once again, is awake. It was about authorship, not religion. 1. SDSU's likely argument. There was no retaliatory intent. The investigation stemmed from concerns about authorship, not religious content. Timing alone is insufficient to prove retaliation under Mount Healthy City Dist. BD of Ejuk v. Doyle, 429 U.S., 274, 1977. 2. Rebuttal. This defense seeks shelter in a shadow. Retaliatory intent need not wear a name tag. It announces itself through timing, context, and cowardice. Plaintiff's religious essay was not followed by applause. It was followed by inquiry. Not because it violated standards, but because it violated comfort. In Nieves v. Bartlett, 587, U.S. Were in 2019, the court affirmed that causation may be inferred when the only trigger is protected speech. The professor, the sole academic authority who read the work, expressly declined to pursue charges. And yet, the university rose up anyway, not with evidence, but with suspicion cloaked in silence. No other student was flagged. No other essay sparked action. Only this one, the singular spiritual cry against conformity. The inference is not coincidental. It is constitutional. This was not discipline. It was reprisal dressed as policy. D. Plaintiff failed to provide specific comparators. Plaintiff has not identified specific students who were treated more favorably. General comparisons are insufficient to support an equal protection claim under Iqbal and Twombly. 2. Rebuttal. This is not a courtroom. It is a maze, and SDSU would have. The plaintiff chased through it blindfolded. In Village of Willowbrook v. Olek, 528 U.S., 562 2000, the Supreme Court held that even a class of one may cry out under the Equal Protection Clause when treated differently for no rational reason. Plaintiff can and will identify students suspected of AI usage who were I. Notified of the allegation, 2. Granted access to the investigative record, 2. Afforded hearings, and 4. Resolved within the lawful 40 working day window. 3. In contrast, plaintiff was denied each of these rights, not for what he did, but for what he said and who he dared to be while saying it. That is not enforcement. It is targeting. The rule was universal until plaintiff invoked a higher truth. The Executive Order 1098 is not contractually binding. 1. SDSU's likely argument. Executive Order 1098 is an internal policy, not a binding contract. Courts have repeatedly held that university handbooks and policies do not create enforceable contracts unless explicitly stated. 2. Rebuttal. This is the voice of the bloated bureaucrat absolving himself with fine print. But law does not bend before every footnote. Where a university sets rules, invites reliance, and induces performance, it binds itself. By equity, if not by ink. In Zumbrunn versus University of Southern California, 25 Cal, 2 to 1. 1972, the court held that even unwritten understandings, when reasonably relied upon, may form the basis of an implied contract. EO 1098 is not a menu, it is a mandate. It promises timely resolution, fair process, and finality. Plaintiff believed it, plaintiff relied on it, and plaintiff acted, graduating under its apparent protection. Then SDSU, with a whisper and a shrug, reversed course and reopened judgment. It cannot invite trust, then punish it. It cannot offer stability, then revoke it. This is not policy, it is betrayal masquerading as discretion. And when betrayal produces harm, the law calls it breach. F. No official record equal to no injury. 1. Likely SDSU argument, no adverse action was finalized. There's no official transcript note or formal penalty. Therefore, there's no cognizable injury. 2. Rebuttal. This is a magician's misdirection that seeks to elevate form over substance. The injury is not limited to what's written in ink on a transcript. It includes the chilling of speech, the anguish of secret discipline, the reputational damage created by unresolved allegations, and the deprivation of a fair process when it was due, as Burlington N. and Santa Fe Rye, Company v. White, 548 U.S., made clear in the retaliation context. Adverse actions include anything that might dissuade a reasonable person from engaging in protected conduct. The administrative hold, the threat of a hearing, the reputational smear, the emotional toll, all these constitute tangible harm. No final punishment is required for constitutional injury when the process itself is the punishment. G. Plaintiff was not entitled to accommodations in disciplinary context. 1. Likely SDSU argument. ADA accommodations apply to academic participation, not disciplinary proceedings. 2. Rebuttal. This argument is not only factually incorrect, it is legally dangerous, if not shameful. The ADA and Section 504 of the Rehabilitation Act do not vanish at the disciplinary gate. In Dovey, Purdue Univ. 928 F. 3D, 652 7th Seer, 2019, the court noted that disciplinary actions can affect access to educational programs, and therefore must be ad accompliant. Plaintiff was entitled to equal access to the process. This includes time, clarity, and reasonable accommodations. SDSU's refusal to honor these terms was not just unkind, it was unlawful. 28 CFRs SS 35.130 and 35.160. Demand effective communication and prohibit discriminatory methods in any program or activity. H. No clearly established law. Qualified immunity applies. 1. Likely SDSU argument. Even if there was a violation, the law wasn't clearly established. Qualified immunity shields individual defendants. 2. Rebuttal. Qualified immunity is not a magical get-out-of-Constitution-free card. In Hope v. Pelzer, 536 U.S. 730, 2002, the court complaint hearing date, time, courtroom, -49, explained that officials can be liable when their actions are obviously unlawful, even absent a case directly on point. Here, SDSU officials violated clearly established procedural rights: notice, opportunity to be heard, timely resolution as recognized. In Gosvi Lopez, Matthews v. Eldridge, and even the CSU system's own EO 1098. Likewise, retaliating against protected speech, especially religious, is a textbook First Amendment violation Tinker MT Healthy, and targeting a disabled student without reasonable accommodation violates unambiguous mandates under the ADA. The clearly established standard is not blind. It sees what SDSU chose to ignore. Plaintiff failed to exhaust administrative remedies. 1. Likely SDSU argument. Plaintiff should have gone through university appeals or OCR processes before filing this lawsuit. 2. Rebuttal. This is weak wizard smokescreen. Section 1983 claims do not require exhaustion of administrative remedies. Patsy, Board of Regents of Fillet, 457 U.S. 496, 1982. Plaintiff is not bound to chase an internal appeal process that was already corrupted, stalled, or weaponized against him. Moreover, plaintiff did in fact seek clarification, resolution, and accommodation. It was SDSU that stonewalled, delayed, and defied its own rules. The law demands process, not a journey through Pan's procedural labyrinth. J. The case is moot or not ripe. 1. Likely SDSU argument. There's nothing left to resolve. The disciplinary process hasn't yet concluded or is no longer active. 2. Rebuttal. The injury is not theoretical, it is ongoing. The matter remains axiomatically open. Plaintiff is still under administrative hold, academic standing remains in jeopardy, and reputational injury continues to accrue. Even if SDSU were to dismiss the case today, the voluntary cessation doctrine, Friends of the Earth via Laidlaw, 528 U.S., would preclude mootness. The sword is still hanging, and it is the threat, not just the act, that gives rise to jurisdiction. The graduation speech was protected free expression. 1. SDSU's likely argument. The commencement speech on May 16, 2025, was protected by the First Amendment. Universities may host speakers whose views are controversial or political in nature without violating Title VI or the Constitution. Plaintiff's discomfort does not transform protected speech into actionable discrimination. 2. Rebuttal. This defense mistakes the First Amendment for a weapon of impunity. But constitutional freedom does not license institutional endorsement of discrimination, especially where a public university, cloaked in state power and funded by federal dollars, uses an official platform to exalt one viewpoint while marginalizing another. SDSU did not merely permit speech. It sanctioned, selected, and amplified it at a capstone event where attendance was functionally mandatory for honor students, graduates, and families. The university cannot drape a podium in neutrality while handing the microphone to a partisanship pundit for the Palestinian cause. As the Supreme Court held in Rosenberger v. Rector, 515 U.S. 819, 1995, viewpoint neutrality is not optional when the state sponsors expression, and where that expression crosses into the terrain of racial or religious animus, as here with a one-sided narrative that vilified Jews, praised terrorist-aligned rhetoric, and excluded all contrary facts. Title VI liability attaches. See Share Tefillah Congregation versus Cobb, 481 U.S. 615, 1987. Plaintiff is not challenging protected expression. He is challenging state-sponsored discrimination cloaked in speech, a distinction both legal and profound. Just as a public school cannot endorse a prayer that excludes religious minorities, so too a public university cannot exalt a commencement narrative that silences, isolates, and intimidates Jewish students by depicting them and their homeland as genocidal monsters. The First Amendment protects private expression, not institutional propaganda that violates civil rights. A university may not use federal funds to create a hostile environment, then retreat behind the First Amendment when the fire it lit scorches the very students it exists to serve. This was not discomfort. It was deliberate exclusion. It was not offense. It was targeted messaging against a protected class. And the Constitution draws its line there, not in pencil, but in stone. Let it be recorded plainly, speech is free. Discrimination is not. SDSU crossed that line, but the law does not blink. Ninth prayer for relief: where law falters, let justice sing. A wherefore, having shown that constitutional rights were not merely disregarded, but desecrated, that the rule of law was not merely bent, but broken, and that plaintiff's dignity was not only slighted, but publicly stripped, the plaintiff respectfully petitions this honorable court, as the final sentinel against arbitrary power, to enter judgment in his favor and grant the following relief. 1. Declaratory relief. A declaration that defendants, acting under color of state law, violated plaintiff's rights under the United States Constitution, including but not limited to 1. The right to due process of law under the 14th Amendment. 2. The right to equal protection under the law under the 14th Amendment. And 3. The right to free expression, religious, political, and academic under the First Amendment. 2. Injunctive relief. A permanent injunction ordering San Diego State University and its agents to 1. Expunge all disciplinary records, references, or internal notations related to the reopened matter. 2. Cease and desist from any further retaliatory, suppressive, or punitive action arising from plaintiff's protected expression. 3. Restore plaintiff's academic standing, transcript, and institutional record to the condition it would have held, but for the unlawful retaliation. 3. Compensatory and consequential damages for reputational harm, emotional distress, psychological trauma, and interference with postgraduate opportunities, including law school admissions, directly caused by defendant's unlawful conduct. 4. Punitive damages, were authorized by law to penalize defendants' willful and malicious disregard for constitutional rights, and to deter future abuse of authority masked as administrative discretion. 5. Such other and further relief, as this court may find just and equitable, not only to make the plaintiff whole but to affirm a deeper principle, that when public institutions violate sacred liberties, the courts must answer not with silence, but with the clarion force of law. Where violations implicate federal civil rights statutes, such as Title VI, the Civil Rights Act of 1964, 45 CFR. SS 80.8 empowers enforcement mechanisms that include the potential termination of federal funding. Such authority is not ornamental. It is the legal sword forged to defend against the erosion of equal protection and the misuse of public power. Let the judgment rendered here echo with that authority, not as vengeance, but as vindication. Not merely for this plaintiff, but for every student whose rights hang in the balance when procedure becomes pretext and neutrality becomes a mask for ideological coercion. Let the court declare that the law still speaks, clearly, courageously, and without delay. 10th demand for jury trial. A plaintiff hereby demands a trial by jury on all issues triable by jury. 11th conclusion. This case is not a mere quarrel over policy, but a reckoning with power misused and justice delayed. San Diego State University, entrusted with the sacred charge of educating minds and guarding rights, instead chose the path of institutional betrayal. It reopened a matter already quashed, wielded silence as a sword, and struck, not in pursuit of truth, but in retaliation cloaked in procedure. And then, like a failed magician with blood on her hands, SDSU waves its wand of procedural language and pretends time has absolved its transgression, as if the clock could erase consequence or silence could cleanse wrongdoing. But no illusion, no performance, no incantation of policy can wash away the stains of constitutional contempt. The plaintiff, a father, a veteran, a student with granted accommodations, asked not for privilege but for parity, yet SDSU trampled due process, mocked fairness, and converted justice into a mirage. The Constitution is not ornamental, it is obligatory. And when an institution claims the public trust, it inherits public accountability. Here, SDSU did not err out of ignorance. It acted with deliberate defiance. Its conduct, complaint hearing date, time, courtroom, -53, violated not just law but conscience. It breached the First and 14th Amendments, ignored Executive Order 1098, abandoned the obligations enshrined in its own disability accommodation letter, and mocked the very principles it claims to uphold. The harm is not hypothetical. It is lived, reputational ruin, emotional torment, and the derailment of a future forged in effort and sacrifice. Therefore, plaintiff beseeches this court not for favor, but for the restoration of order, for vindication, not vengeance. Let this court declare unequivocally, 1. That SDSU's actions transgress the plaintiff's rights under the Constitution and federal law, including the First Amendment, the Due Process and Equal Protection Clauses of the 14th Amendment, 42 U.S.C. SS 1983, and the California Bain Act. 2. That the university's breach of its own procedural promises and disability accommodations constitutes actionable injury under the doctrine of implied contract and promissory estoppel. 3. That the plaintiff is entitled to full and just compensation for the emotional, reputational, and academic harms unjustly inflicted. 4. That the retaliatory proceedings be expunged and the plaintiff's record restored to the condition it would have held but for the university's misconduct. 5. That the defendant be enjoined from reviving this matter or from further retaliation. 6. And that justice, measured not by convenience, but by principle, be done. Let it be affirmed that public power does not exist above the law, but beneath its yoke. And let this court be the place where that yoke is once again made firm, where the law is not bent by bureaucracy nor buried beneath bad faith, but held high as a banner of protection for all who walk under its promise. For if not here, then where? If not now, then when? And if not for this, then what is justice for? Dated July 3rd, 2025. Plaintiff,